All right, so we are here on the case of Williams versus Wines, 22-1919. These arguments are being live streamed. Introduce the other members of the panel. If you have any electronic devices, make sure they're in the silent mode. Each side will have 20 minutes. Appellant's counsel, if you want to advise me how much time you want to reserve for rebuttal, I'll try to help you in that regard, but there is a clock on the screen there. And so with that, Mr. Eagleton, you may proceed.
Thank you, Your Honor. Good morning, and may it please the court. I'm Joe Eagleton with Brannick Humphreys and Berman here this morning for the appellant, Lori Williams. And if I could, Judge Evander, I'd like to reserve 5 minutes for rebuttal.
Okay, that's fine.
Thank you. So we see this as a pretty simple case that should compel a pretty straightforward reversal. As the court is aware, this is a trust case. It was filed by the appellee, Bobby Wines, seeking basically to appoint herself as trustee of the A. Dean Wines Trust. There are lots of substantive problems, we think, that we've alluded to and pointed out in the briefs with this petition, like the fact that A. Dean Wines is the living current trustee of the A. Dean Wines Trust, which was not mentioned or referenced in Bobby's petition. But putting those substantive problems aside, because those are really problems for another day, under the plain language of the Florida Trust Code, this is section 736.0201 of the Florida statutes, a case like this is initiated and filed like any other civil case. And like any other civil case, it proceeds under the Florida Rules of Civil Procedure. And of course, under the plain language of the Florida Rules of Civil Procedure and decades, if not centuries of precedent, when you initiate a new civil case, you have to serve the parties to the case. And so the parties to a case like this are, at a minimum, the settlor of the trust, here that's A. Dean Wines, the current trustee, that's also A. Dean Wines, and the beneficiaries. And we've cited the cases like the Demirkan versus Mikhailov case from the 3rd DCA that make clear that at a minimum, the parties to a case like this are that group I just referenced, the settlor, the trustee, and the beneficiaries. Now, there may well be more parties to a case, but to a trust case like this, including any interested persons that go beyond that group. But that group, at the least, are the parties to the case. And so there's no dispute here. Bobby Wines has always admitted that she did not serve anybody, including A. Dean Wines or my client, Lori Williams. And so really the only way around this is if she didn't have to serve Lori Williams. And the trial court offered one reason and one reason only why that was the case. And that reason was that Lori Williams' lawyer had notice of the filing because Bobby's counsel, Mr. Dean, sent Lori's counsel a letter basically saying, hey, I filed this petition. Let me know if you have any questions. And of course, notice, as we pointed out in the briefs, under well-settled and binding precedent, including as recently as the 2018 Moss versus Hudson case from this court, says very clearly that notice of a lawsuit is not the same thing as cannot cure and cannot replace service of process, which, as I said, is mandated by the Florida Trust Code and the Florida Rules of Civil Procedure. The trial court did not address those cases, did not reference those cases, did not distinguish those cases. And frankly, I don't think the answer brief really has anything to offer about those cases either. And that's because I think there's nothing to offer. Those cases are clear, those cases are binding, and those cases make it, I think, plain that the trial court erred as a matter of law in saying that Lori Williams' notice of this lawsuit could fix the fact that she was not served with process as the trust code and the rules required her to be.
Mr. Eagleton, what's your best case for saying that Lori Williams is an indispensable party?
I think the Demirkan case that I referenced previously, that's a 2020 3rd DCA case that we've cited, that case says this is a quote from the case, generally the only indispensable parties to a trust action, including a modification, are the trustee, the settlor, and the beneficiaries. I think the Sylvester case, which is a fourth DCA case, say that the court did not have, in that case, jurisdiction essentially because the trust was not before it. And that was because absent joinder of the trustee and in that case, it was the contingent remainder beneficiaries. Those were all indispensable parties to the case. We've talked about some other cases in the briefs. The Barley versus Barkis case, I think, makes clear that even a contingent beneficiary is a party to a trust case. And again, the trial court found that Lori Williams was an interested person here. There's been a lot of discussion in the answer brief about whether she's a qualified beneficiary. I don't see any authority that required her to be that. We can talk about that if the court wants to. I think it's plain here that she is a beneficiary under on the face of the governing Second Amendment to the A. Dean Wines Trust. She's listed right there. Her name is there. It says Lori Williams may inherit from this trust. So, she's clearly a beneficiary of this
Mr.
trust.
Eagleton, and I believe there was quite a bit of time given in your opponent's brief to the distinction between indispensable party and interested party. Is that a designation that we should focus on and concern ourselves with?
No, Your Honor, we don't think that's a distinction without a difference under these facts. As I've alluded to, I don't think authority that has been cited to try to make that distinction. I think that's overcomplicating the issue here, frankly. Like I said, those authorities that I was just referencing in response to Judge Edwards' question, none of those cases make that or draw that distinction. They simply make clear that the beneficiary of a trust is a proper party. In a case like this, the Barley versus Barkis case, in fact, actually, uses the interested person language. So, to the extent we're going to start drawing any kind of distinctions here, I think that the interested person standard, which of course is the standard the trial court actually did employ here, is the correct standard. Mr. Dean has conceded here that Lori Williams is an interested person. I frankly, I don't know why she's an interested person, if not for the fact that she's a beneficiary. I mean, there's lots of reasons she's interested, but the other side has conceded here that she is an interested person. And given that, she had a right to participate. But to the broader point, Judge Wallace, no matter how you slice it in this case, these distinctions don't really matter because Lori Williams is an interested person, as the trial court found, and as the other side has conceded, she's a named beneficiary right there in the Second Amendment to the trust. She's listed. And, if we're going to go to the qualified beneficiary issue, which is a sort of a subset of all beneficiaries, again, I don't think we need to, but even if we want to employ that standard here, she is the qualified beneficiary because the beneficiary of this trust, right on its face, says the trustee or successor trustee of the Robert L. Wines Jr. Revocable Trust, this separate trust. And again, the other side has conceded that person is Lori Williams. And so, these distinctions under our facts are not relevant, but I would submit to the court that there's really no reason even to go there. The trial court didn't draw those distinctions. The trial court's only rationale here was that actual notice sufficed to replace service of process. And as I've already said, I think there really is no dispute under the law that that's simply it's simply wrong. Notice does not replace service.
Even if actual notice was sufficient, would you also be entitled to notice of any hearing prior to the order being entered?
Yes, Judge Evander, I think that's a good point. I mean, even if, so we're on notice of the fact that this was filed, the very next thing on the docket that happened here is that the trial court enters this order appointing Bobby Wines as the trustee. So I think that, Your Honor, you're raising a great point under our facts, which is I'm not sure what notice in this particular case did to help us, because even if we're, monitoring the docket, daily, maybe we file the exact same motion that we're here in front of the court talking about a few weeks sooner, but the trial court essentially enters this order without any kind of further notice. There was apparently no hearing. I'm frankly not sure how this order got entered, but certainly Lori Williams didn't know about it, and that's why we're in the posture that we're in now.
Bobby Wines didn't name or serve anybody, did she?
That's correct, Your Honor, and as we point out, including Adine Wines, who's the settlor and the current trustee, who's never been removed as the trustee. So no, there were no parties named, no parties served. I think Mr. Dean will correct me if I'm wrong. I think that's conceded and undisputed here. And so I think that's why the only thing that the trial court had to go on was that Lori Williams had actual notice of this lawsuit, because there were, as you pointed out, Judge Edwards, there were no other parties named, no one was served. This order got entered appointing Bobby Wines as the trustee. It did not, by the way, remove Adine Wines as the trustee. It just says Bobby Wines is now the trustee. So I think there's lots of problems, frankly, with the order that the trial court entered. And as we've said, I think those problems could have been most likely avoided if Bobby Wines had simply done what's required by the trust code and the rules of civil procedure and served the other parties to the case, with the complaint when it was filed in the first place.
And it would appear, wouldn't it, that the ultimate goal here is to eliminate Lori Williams as a beneficiary by seeking to declare the Second Amendment to the trust as void for lack of capacity on Adine's part?
It does appear so, Judge Edwards, which is, I would say, all the more reason why it's pretty clear that Lori Williams is an interested party and a person who should have the right to participate in these proceedings, as somebody whose rights under this trust are essentially being, attacked by Bobby Wines. I don't know the substance of those questions is for another day, I think, but clearly, I would say due process and the rules require that if a person is going to come to court and seek to take some action that affects Lori Williams' rights under these trusts, Lori Williams has to be a part of that conversation and that proceeding in court. And the way to make her that was to serve her with the petition, the complaint, which of course then would have triggered under the rules, an obligation on her part to file an answer. I think that's an interesting point. The timeline for answering a complaint runs from service. So I think it's very clear that service is required here. It's very clear service was not made. I really don't think there's any rationale that can support what the trial court did here in not vacating this order and requiring service and letting Lori Williams participate in the proceeding.
Is there other contention that the Second Amendment was not properly executed?
I don't think, Your Honor, that there's any contention that this. I think the other side is arguing now that the Second Amendment to the Adine Wines Trust should be invalidated because of a capacity issue that they want to argue about whether Adine Wines had capacity. The Second Amendment has not been, as far as I know, invalidated. It certainly wasn't invalidated when this complaint was filed. There's some question, I think, about whether this other trust, this Robert L. Wines Jr. revocable trust, this special trust, was properly executed or not. Again, we think that's a question for another day too. The Second Amendment to the Adine Wines Trust that we're talking about says that the beneficiary of the Adine Wines Trust is the trustee or successor trustee of this other trust. And that person is Lori Williams. And so, there may be some question about that for another day, but where we are
Your
right
basic
now,
argument is the trial judge put the horse before the cart or the cart before the horse if the trial judge addressed these substantive issues without getting an answer and evidence and argument from the parties.
right, Your Honor, essentially that's I think our position is that even if we wanted to talk about, those issues, it doesn't impact the question of whether Lori Williams is a beneficiary or a qualified beneficiary. And I'd be happy to address that in more detail if the court wants. But I think your point is our primary point, Judge Evander, which is this is all premature. At the stage that we were at in this case, there was no reason to talk about those substantive questions because it's clear under the law that Lori Williams had a right to participate. And because she had a right to participate, she had to be served with the complaint. Because she wasn't served with the complaint, the order appointing Bobby Wines as trustee is void, and therefore the trial court erred in not granting the motion to set it aside.
Okay, you're at 4 minutes and 25 seconds for rebuttal, and we'll hear from Mr. Dean now.
Yes, thank you, Your Honor. Jonathan Dean on behalf of the appellee, Bobby Wines. The sole issue on appeal here is whether Miss Lori Williams, the appellant, is a qualified beneficiary of the Dean Wines Trust, such that she would be entitled to formal notice of the petition by Bobby Wines for the appointment as successor trustee under Florida Statute 736-0704. If Miss Williams is not a qualified beneficiary, she has no right to formal service of a petition to appoint the successor trustee of a trust under that statute. And to determine whether she's a...
Let me ask you this.
Yes, Your Honor.
Even if she wasn't entitled to formal service, would she be entitled to notice of a hearing?
There was no hearing in this case,
Right.
Judge. The court entered the hearing on the basis of the petition without further notice to me or to anybody else.
Yeah, so my question is, would she be entitled to be heard by the judge, regardless of whether she is a qualified beneficiary or just an interested party?
It's possible she may be, Judge, but the court ruled that the service that was given to her attorney with a copy of the petition 60 days prior to the entry of the order was sufficient notice to her as an interested person. She's not an indispensable party. She's not a qualified beneficiary entitled to participate in this case. And for Mr. Eagleton and the appellant to raise on behalf of every other person who may be a party to this action, all their defenses and rights, I think is improper. And it broadens his argument and then the scope of this appeal beyond what is actually the issue. So when you look
Mr.
at...
Dane, Mr. Dane, excuse me, it kind of looks like Bobby Wines rolled out of bed one day and decided she wanted to be trustee. Nobody was named, nobody was served, no process was issued, no hearing was held, no notice of hearing was held. Dean Wines was not removed as trustee. I mean, there's just an awful lot of, not sure what the right word is, but a lack of proper procedure being followed here. And it seems to me that beneficiaries, several cases mentioned that beneficiaries are indispensable parties. Under the trust code, a beneficiary includes a contingent beneficiary, which I think you have to admit that Lori Williams is certainly a contingent beneficiary, isn't she?
No, Your Honor, she is absolutely not a contingent
How is that?
beneficiary. Well, because we look at, to determine who are the beneficiaries, we look at 736-010319, which talks about the qualified beneficiaries. These are the only people who are entitled to participate in a successor trustee petition hearing or petition like was filed in this case. And when you look at 736-010319, you find that the qualified beneficiary is a distributee who is also a means of beneficiary or a permissible beneficiary of trust income or principal, or who might become one if certain things happen. And
right, and the second amendment names the trustee or successor trustee to the Robert Wines Jr. as the beneficiary, does it not?
It doesn't name her as a as trustee. No, it names her as a beneficiary, provided the Robert Wines Jr. Trust is terminated. And Robert Wines Jr.'s
No,
trust.
no, I think, counsel, I correct me if I'm wrong, but I thought that the Second Amendment did two things. One, it says that whoever the trustee or successor trustee of the Robert Wines Jr. Trust is the sole beneficiary. And then it says, if the Robert Wines Jr. Trust is terminated, then Lori Williams by name is the beneficiary. Am I right on that or not?
I don't believe that's exactly how it's worded, Judge, but what I think that it intends to be stated is that the trustee of the Robert Wines Jr. Trust is the person to receive any assets from a Dean Wines Trust once a Dean Wine passes away. And then, so that person is in an administrative capacity as the trustee, not
Well,
as
but that's
the
not, I'm
beneficiary.
talking about the literal language of the Second Amendment. Doesn't it create the trustee or successor trustee as the beneficiary of a Dean Wines Trust?
Yes, Judge, but when we talk about in actual practice, the naming of a individual to serve in an administrative capacity does not name them individually. It names them as their administrative capacity, and there's a difference there.
Well, that's a difference that needs to be adjudicated at some point, doesn't it? I mean, if we just look at the literal language of the Second Amendment, which has not been revoked or declared invalid, right now, Lori Williams, two different ways, is a contingent beneficiary, isn't she?
I still would disagree, Judge, because she's not a beneficiary if the underlying Robert Wines Jr. Trust cannot be terminated, which it cannot due to his death. It's now irrevocable. And secondly, because it names her as in the capacity of a successor trustee, she does not take the property in an individual basis, but only as a trustee, successor trustee, not as a beneficiary. So therefore, when we go back to the whole determination of a successor trustee under 736-0704, we look at who's entitled to participate in that decision. And
Well, how is Bobby Wines entitled to be named trustee ahead of anybody else?
Well, Bobby Wines is a granddaughter of Mrs. Adine Wines. She has been serving as a power of attorney for her. She was named along with her sister as the successor beneficiaries under the original trust and under the First Amendment, which named it to her father's trust. And now that the Second Amendment has been entered, but has now become, because of its defect, it becomes a trust that receives the property for the benefit of the intestate heir of Robert Wines Jr., which is his wife, Bobby Wines' mother, Miss Mary Ann Wines.
Those are all wonderful issues to be litigated, but I don't think Bobby Wines can roll out of bed and say, this is the way the world is according to me, and everybody else take a hike. I mean, how do you say that somebody who is listed indisputably, I hear what you're saying, but on paper, she is a contingent beneficiary in two different ways, and she's entitled to no notice while your client gets rid of the Second Amendment to the trust? I can't conceive of it, and you haven't convinced me yet.
The Second Amendment, Judge, is not before this court for determination. The only thing before this court for determination is whether or not Lori Williams was entitled to receive formal notice for the original petition, and not for the second petition. We're not here about that. There's no appeal on that. This is for this one issue. And so when you look at this sole issue, the only way she's entitled to formal notice is if she's a qualified beneficiary. And if she's not a qualified beneficiary, then she's not entitled to formal notice. That's period. That's the end of the inquiry. But she did receive notice, and the court found that she was an interested person. Why is she an interested person? Because she is the personal representative of Robert Wines Jr.'s estate since he died, and she is also the successor trustee of his trust.
So since Florida statute 736.0201(1) says that this kind of proceeding should be commenced by filing a complaint, and that you follow the rules of civil procedure, and rule 1.070 says summons issue, why wasn't that done?
Because the summons issue, well, why it was done for any other persons, I don't think is before this court, but why it wasn't done for Lori Williams is because she's not entitled to receive formal service. And she did receive notice, adequate notice that entitled her.
What case do you have that says actual notice is a substitute for service of process?
I think that we referenced in our brief, but I don't have her here in front of me, Judge, but the point is that she had actual notice. So if the whole goal of service of process is to give opposing parties an opportunity to participate by receiving notice, when you receive actual notice, you've got the notice. Whether there was served by a process server or a sheriff's deputy is irrelevant. She received actual notice, and she did not do anything until after the order was entered, until after the second petition was filed. And that second petition is not before this court. The only thing before this court is, did Lori Williams receive the notice she was entitled to? And the answer to that is she received adequate notice according to the trial court judge, and that ruling should stand. Why was she not entitled to formal notice? Because she's not a qualified beneficiary. And she hasn't proven that she is a qualified beneficiary. She's named as a personal representative. She's named as a successor trustee. She may, under the second trust amendment to a Dean Wines trust, receive a benefit if Robert Wines Jr.'s trust is terminated, but it cannot be because he's dead, and the trust that's expecting an inheritance from his mother, as this one is, cannot be terminated. So it will go when a Dean Wine dies, because she's incapacitated and can't change her trust. It will go, if the Second Amendment is not revoked, it will go to Lori Williams.
Mr. Dean, what was the evidence? You mentioned the incapacity, but what was the evidence before the trial court of the incapacity?
I don't believe there was any evidence before the trial court. Judge, you have to remember that in family trusts and family business as this is, the people, the children, the grandchildren, and so forth are there to help the elderly senior people. In this case, Mrs. Dean Wines. So the granddaughter is coming forward to help her because she's not able to take care of her own business. Her son, who was taking care of her business, had died. So somebody needs to take care of her business. And so the granddaughter, and the discussion amongst
your allegation was that Miss Adine Wines was incapable of taking care of her own business, but
that's correct.
That was a hollow allegation. From what I can tell, there was no supporting proof that was required under the trust. Is that correct?
Well, in the second, since the second petition that was filed for removal.
The one that's not before the court, counsel? The one that's not before the court that you don't want us to consider for other reasons? You now want us to consider that?
I agree. It shouldn't be considered at all, Judge. But the court allowed Mr. Eagleton to talk about it and has asked questions about it. So in that petition, there was attached the evidence that the court is asking about now.
Not signed by a physician, was it?
Not by a physician, no.
The trust requires it to be signed, that it requires certification by two physicians, at least one of whom hasn't recanted or withdrawn. And here, what do we have? An advanced nurse practitioner?
That's correct.
So that doesn't comply with the trust, does it?
There was a second physician who also has it, but it wasn't attached to the petition. But we didn't get to an evidentiary hearing on that issue, Judge. And that's, again, not before the court. But to answer the court's question as to what evidence there was evidence provided in the second petition. But back to this petition, in this case, if you have one issue, which is, was Lori Williams entitled to formal service, you have to ask the question, is every person who may have some interest in the assets of Adine Wines Trust as an administrator of a second trust or the administrator of a second estate, is that person a qualified beneficiary entitled to formal notice? And since 736-0704 says that those persons who are qualified beneficiaries have the right to participate, our position is no, she was not. She was not entitled to participate, therefore she's not entitled to formal notice. And the notice that she did get was sufficient to allow her to take some action, and she took no action. So that may constitute a waiver on her part until the second motion was filed or petition was filed, and then she got interested.
Mr. Dean, is your argument that she was entitled to no notice and that the actual notice she received was just a bonus for her?
Well, I think she was an interested person, and she did receive notice to her counsel. So I
Well, if
think
she's entitled to some notice, then, going back to Judge Edwards' question, do you have any case law that says actual notice can replace legal notice? Because, I would guess that one of the reasons for the rule in the first place to have procedures for notice, so you wouldn't get into factual disputes about, well, I gave actual notice, no, you didn't, yes, I did, no, you didn't. So we put it, so the rules and statutes provide for, in essence, some neutral party to show whether it's, even if it's by mail, but by service. So going back to Judge Edwards' questions, is actual notice a substitute? If not, then it seems to me you're stuck with the argument that she wasn't entitled to any notice at all.
No, Judge Vander, I don't think so. She was entitled to notice, and she did receive notice to her lawyer, which the lawyer admitted in the hearing that they did receive it, and they received it some 60 days prior to the entry of the order. So they had notice. So to answer your question, you say, well, the reason why we have these rules is so that there's a record of a third-party independent service, and we can default somebody if they don't respond. That wasn't the case here. He did receive notice. He did participate.
Right. But that goes to Judge Edwards' question. Do you have any case law that says actual notice can be a substitute for legal notice?
I don't have any to report to the court today.
Right.
But I think that on our brief, we did address that.
Okay. All right, any other argument?
May I continue?
Yes.
Okay. So when the court looked at this situation with Ms. Williams upon their petition and had heard the oral arguments of the counsel and considered all these factors, the trial judge looked at her and found that she was an interested person and that she was not a qualified beneficiary under this statute, 736-0103-19. And as such,
Let me ask you this, another question. One of the things the summons provides is you have 20 days to answer.
Yes, sir.
Here, there's no summons. How would the recipient of the letter that, this petition has been filed, know that the judge would handle it without a hearing, or they're required to file something? Or because I do have a second question about the lack of notice of a hearing. So let's say she has a right to be heard. Is that right to be heard worth much if you don't get notice of a hearing? And I assume your argument is going to be, well, she should have acted, but usually that's in the summons, isn't it?
Yes, the summons is there to help people who may not be familiar with what the rules are, procedures are with regard to these matters. But this was notice that was given directly to her attorney, Mr. Weechins, who's been practicing law for 40 years nearly. So he knew what he should have done, and he didn't take any action. And now the court entered this order. And so then 30 days after that, then he files this petition to the motion to strike. But
How soon after they became aware of the order through the second petition did they file the motion to set it aside?
I think it was, well, they received the notice, and I think it was almost 60 days or maybe even more than 60 days before they filed their petition. And it was more than 30 days after the court filed its order.
Was that order, was the order served on her?
The order was, I don't believe was served on her, but the order
Was it mailed to her?
It was, she did receive a copy of the order, yes, sir.
At what point?
I don't recall the date, but I think it was prior, certainly prior to their filing of this petition.
Shortly prior to, wasn't it served as part of the petition, or wasn't there a reference in part of the petition or motion to set aside the Second Amendment? Isn't that how they got it?
That could have been correct, Judge, but it was still prior to their filing their motion to set aside the order.
Right, but shortly, in other words, shortly before. It's not that they waited. Once it would appear from the record that there's a possibility that they didn't learn that Bobby had been appointed as trustee until they got the petition or motion to set aside or question the Second Amendment. Isn't that correct?
I think that is correct.
Okay, so if there's no notice of hearing, I mean, say somebody did send a petition to council, isn't council entitled to sit back and wait and be notified if there's going to be a hearing on that?
Well, Judge, the court entered the order without a hearing, and so I don't know the answer to that question. Probably if there had been a hearing, then he would have been able to appear and participate in the hearing.
Well, you would have felt obligated to give him notice that there was going to be a hearing, wouldn't you?
Yes, he was an interested person, so he was entitled to have that information.
Right, but nobody gave him any notice that there was going to be a ruling on that motion, on the petition rather.
That's correct, because the court did that without further hearing.
Does it hurt any less that they weren't given notice because the court did it on its own?
Well, I think the broader issue is, what right to participate does she have? If she's not a qualified beneficiary, then she has no. This woman is not a part of an heir at law. She's not an heir under any set of rules. She's nothing. She's not a family member. She's an outsider to this family. She's not part of the Wines family.
She's a beneficiary under two different ways. She's not nothing. She's not somebody who came rolling in off the street. She's named in the documents as a contingent beneficiary. I understand that it seems odd to name it the way that they did, but until it's changed or properly adjudicated otherwise, she's named either as the successor trustee under the Robert Wines Jr. Trust, or if the Robert Wines Jr. Trust were to be revoked, she's named there. None of that has happened, I understand, but she's there and she's being ignored as though she was just somebody who, rolled in off the street and decided she'd hang out with you guys. And it doesn't make any sense to me.
Well, Judge, the only thing I can tell you is that if we're going to limit our discussion today to what her interest is to participate in this formal hearing or the formal petition, she only has an interest if she's a qualified beneficiary to actual participation. So her interest as a interested person, the court felt that her notice that was given to her was sufficient to put her on notice of the petition. So
the trial court also looked at service of process as permissive rather than mandatory, didn't it? Just in general?
No, I think it looked at the actual notice as being determinative. If someone is entitled to notice and they receive actual notice, then the court felt that the burden to give them information to allow them to participate has been met. And that's really part of the issue here. If someone has actual notice of the hearing, then you've met the test of what the purpose of formal service is about, is to give somebody actual notice of a pending matter. And she received that.
Does the record reflect how many people received notice of the first petition?
The record does reflect that, Judge, in that Mr. Weechins, the attorney for Lori Williams at the hearing, acknowledged before the court that he did receive.
No, I'm talking about any other person.
That any other person received notice?
Right.
The record does not reflect any other person receiving notice, but as I had indicated prior, in a family operation like this, the only other people who would have been entitled to receive notice would have been Bobby Wines, the petitioner, her sister, Mary Nolan, and her mother, Mary Wines, and both of them had notice of this. Mary Nolan, the sister, received a copy of the same letter that Gene Weechins did, and the mother is also my client, and she received notice directly from us. So everybody's participation and agreement. So the qualified beneficiaries, those three ladies, the qualified beneficiaries all agreed that Bobby Wines would have petitioned to become Grandma's successor trustee.
Was that filed? Was there a pleading filed where they agreed to that?
There was no documents filed to that. We had a meeting in my office about that. So this is how
So it's not part of the record at all, correct?
It's not part of the record.
Okay.
All right, your time is up, so let's go ahead and hear rebuttal from Mr. Eagleton.
Thank you, Your Honor. I'll try to be brief. There is no case that I'm aware of, no case that's been cited either in the answer brief today or by the trial court that says notice replaces service or process. There are lots of cases, including binding cases in this court, that say exactly the opposite, which is that actual notice cannot and does not replace service or process. There seems to be some discussion about the reasons for that. I'm not sure the reasons matter when there's binding cases that the trial court was required to follow, but I can think of lots of reasons why notice does not replace service, including that lawyers file lawsuits all the time and then decide that they're not going to proceed with them, not going to do anything with them. It would completely invert the way the rules work to put the onus on the party who's being sued to do something before they are served with process as the rules require them to be served. The Second Amendment, I think Judge Edwards referenced this, but this is at page 10 of our appendix. The Second Amendment is very clear who the beneficiaries of this trust are. It says that the beneficiary is the trustee or successor trustee of the Robert L. Wines Jr. Revocable Trust. The answer brief in this case concedes that that person is Lori Williams. I don't think it's any more complicated than that. To the extent it is more complicated than that, the first contingent beneficiary under the Second Amendment of the Dean Wines Trust, it says 100% to Lori Williams. All the arguments that we're talking about today might be great arguments to be made in the trial court. The reason that none of these issues are in the record is because nobody else was able to participate in this case, because nobody was served with either the complaint or the trial court's order. Judge Edwards, you asked how quickly my client moved. It was within 2 weeks, I believe, of finding out. I mean, Mr. Dean seemed to be making a suggestion that 60 days would be too long to wait. Under Rule 1.540, the only timeline we could possibly be talking about here is 1 year. We're well within that, and certainly nobody here sat on their rights. There's no finding of waiver, anything like that. Again, the only thing the trial court decided here was that actual notice replaced service of process. That's completely inconsistent with Florida law, as we've talked about, and that has to be reversed. I'd be happy to talk more about this sort of distinction between interested persons, named beneficiaries, qualified beneficiaries, if the court wants. But frankly, I think that's really just an effort to overcomplicate what's a very simple case here.
Do take a few seconds again, because Mr. Dean is very, very confident that the fact that she was, number one, not a qualified beneficiary, and as such was not entitled to formal service of process. So please do touch on that again.
Sure, Judge Edwards. Well, I haven't heard any authority being cited for that proposition, either a case or anything under the Florida Trust Code. But the Barley versus Barkis case talks about interested persons having a right to participate, specifically references the statutory definition of interested persons prior to finding that I think it was Ms. Barley in that case was a contingent remainder beneficiary and therefore had a right to participate. The cases I referenced in my earlier argument, the Demirkin case, makes clear that at the very least, someone who's a named beneficiary is an indispensable party in a trust proceeding. All we have to do is look at the Second Amendment to this trust, as I've said, to see that Lori Williams is named as a beneficiary. She's also a qualified beneficiary. And again, the trial court found her to be an interested person. And I have also not heard any reason why she would be an interested person, if not for the fact that she's a beneficiary of this trust. And so if she's, entitled to some kind of notice, it's because she's a beneficiary. And if she's a beneficiary, she must be served with process. I see my time is up. And so unless the court has further questions, we would ask the court to reverse the trial court's ruling.
All right. Any other questions from the panel?
No.
All right. Thank you both for your arguments. We appreciate them, and we will be in recess.
Thank you, Your Honor.
Thank you, Your Honor.